Welcome everybody to today's webinar, Understanding Commercial Real Estate Contracts. I'm your host, Steve Wallace. So here's what we're going to discuss today. We're going to go in depth on the different terms incorporated in a commercial real estate contract, including the different provisions outlined below. The webinar is going to be roughly about 35 to 40 minutes, and then I'll give more than enough time at the end for questions. So I guess the first question that a lot of folks ask, especially folks that are new to the industry, or were folks that were investing in residential real estate and now are looking to invest in commercial real estate, or brokers that were involved in residential and looking to jump into commercial real estate. The first question I always get is, whether there's a form real estate contract for commercial real estate transactions. And the answer is there are some form real estate contracts, although many of them are kind of just a broad template versus an in-depth treatment of the particular asset class that you're looking for. And so, there are, and I can refer you all to some form real estate contracts. The Florida Realtors Association has a form real estate contract. There's also the New York City Bar Association also has a form commercial real estate contract. Other local commercial real estate boards have them. Some other bar associations do. But generally speaking, the commercial real estate contract really is tailor-made to the particular transaction, and even more so to the particular asset class. And especially in commercial real estate, everything is negotiable. And so that's the most important thing. And even more so, you have to tailor-make your real estate contract for the particular transaction involved. So the first step, which is generally the first paragraph of the contract, is the party section. It'll be, this contract dated blah, blah, blah is between so-and ABC LLC as seller and XYZ LLC as buyer. So the first question and the first best practice is, don't trust the tax rolls or the property appraiser. You always want to get a copy of the underlying deed. And in most jurisdictions, they're available online. And you generally, the best way to get it is you go to the clerk of the court or the county recorder of the particular county that the property is located. And that's where you're able to get the copy of the particular deed that you're looking for. And most importantly, that's going to have the proper tax folio number, property identification number, and legal description. And then the next question you have is the party that is signing this contract, do they have the proper authority to enter into this particular transaction? And a best practice, and look at my best practice number 2, ideally, you want an entity resolution, assuming that's an entity. And mostly in commercial real estate transactions, there's an entity involved versus an individual. And we'll go into depth in a moment on what to do with different individuals and different scenarios when it's a non-entity owner. But you want to see, ideally, and everything that I'm mentioning to you, I'm sharing with you because it's been my experience in transactions. And in addition to commercial real estate transactions, I also handle real estate litigation. And so a lot of these war stories have evolved as a result of litigation that I've been involved in. And there's litigation that we just settled on behalf of a client, where one of the owners of the entity said that they did not consent to the sale of the property. And so ultimately this evolved at closing when the seller could not sell the property because the title company was requiring a corporate resolution signed by all of the owners of the company to transfer the real estate. And generally speaking, when we deal in, in transactions where an entity is selling, in addition to the deed, we would record a resolution and an affidavit signed by all of the owners of the company authorizing the seller to sell. And in this situation, the seller didn't authorize it. And then ultimately, really what it involved was a dispute over the distributions of the proceeds to the members. So that's why this best practice is extremely important. Another red flag, and I know we have a bunch of real estate agents online today for this webinar, and a best practice both for a buyer as well as a listing agent is you definitely have to have the authorization of all the parties involved before you list a property or before you enter into a contract. But it gets even more precarious when the seller is an individual or a couple, a non-entity seller, and they're going through a divorce. Always, 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 if you know that a seller is going through a divorce, make sure you have a consent to both of the parties, whether or not both spouses are on the deed, because more likely than not, this property can be subject to a claim in their divorce. And the last thing you want to do is go to closing and a closing doesn't close because you don't have the proper authorization. Additionally, when you know that one of the parties died or one of the parties is deemed judicially incompetent and there's a guardian appointed, you have to get the signature of the personal representative if it's a probate, or the executor, depending upon which jurisdiction, or executrix, depending upon which jurisdiction you're in, or you need to get the consent and the signature of the guardian of the party that's deemed incompetent. Lastly, before as a buyer you sign a contract, you always want to review the court docket of the county where the property is located to see if the property is subject to a foreclosure proceeding. And we talked about this for those of you who attended my webinar about a month ago on understanding and the legal pitfalls of distress transactions. You always want to know if this property is in foreclosure or is a property subject to litigation. I just closed a transaction a couple weeks ago, and we knew about it ahead of time, but the property was subject to an eminent domain proceeding. And what was happening is the state of Florida was coming in to widen a major artery known as Boynton Beach Boulevard, and some of my local folks know what I'm talking about. And they were going to take a portion of my client's parking lot. And as a result of that, the lender was looking, and they actually delayed the closing because they wanted to do a new appraisal on the property without that particular section that the state was going to take. So these are all considerations that you must make when you are involved in these types of transactions. And again, for my real estate agents and brokers out there, you don't receive any commission unless you have a proper contract signed. You won't have a proper contract signed unless you follow these best practices and avoid the red flag that I mentioned to you. And again, if you have any questions that are anywhere throughout the seminar, please use the chat window so that you're able to ask those questions, and I'll stay as long as I need to answer your questions. Okay, so we've covered the parties of the contract. Now the next step that we need is we need to cover the property. And again, I'm going to share a couple war stories with you that have occurred in some of my transactions and litigation that we were able to resolve. And the goal is, we want these deals to close. We don't want lawyers to get involved and litigate over matters. The key is for us to be as detail-oriented as possible and have all the information necessary so that we're able to properly document the contract so that there's a clear meeting of the minds of the parties involved. So when you're identifying the property, and we're going to talk about identifying real property and then also identifying personal property. So in your contract, you must list all of the tax identification numbers or partial identification numbers. They're called different things in each jurisdiction, so I just want to use those two terms, which can often be used interchangeably. And most importantly, you must have the correct real property legal description. Now, it's easy if you're dealing in a property that has been platted. It's also easy if you're dealing with a condominium unit, a commercial condominium unit, but where it's more difficult and depending upon the jurisdiction, surveyors and the county, the property assessor, or however you call it in your jurisdiction, they may not have such accurate land records. And ultimately, you know, I'm too young to know this, but when I was in law school, the courthouse used to keep abstracts, and that basically was the recorded land records of the county, which will go back to depending upon how, you know, for example, if you're in New York or Massachusetts, it will go back as far as, you know, the Queen of England, or for example, in Florida, it's going to go to the Spanish crown. And so those land records go that far back. So the reason why I'm going through this and explaining it to you is because you must have an accurate legal description. And don't rely on the tax records. Don't rely on, you know, the listing agreement in CoStar or MLS or LoopNet or wherever you get the listing information. Again, just like I mentioned in the initial section about parties, it's so important to get that deed. That is the key. Because without the deed, you don't have the proper legal description. And I'll caution you, and that's one of the main reasons why you get title insurance, is oftentimes the deeds have errors, and there could be an error that's picked up during the title search, and it could also be an error that is picked up, you know, throughout the process. So I can't stress enough for you to check, and double check, and triple check the legal description. Because we've had litigation where a seller did not want to sell the property and then ultimately would only agree to sell what was spelled out in the legal description, which was spelled out in the contract. Unfortunately, the legal description in the contract and the tax ID number was incorrect in the contract. So my client had to spend thousands of dollars to litigate that issue, which could have easily been solved if there was a proper determination of the legal description at the time. And ultimately, you know, you may not know. And so what we oftentimes do in the contract is we will attach the legal description that we have, and then ultimately you will you'll have a surveyor during the due diligence period make the determination of what the proper legal description is, and we'll go on into it a little later. During the title and survey period, there could be objections to the accuracy of the legal description. So again, that's why we review the prior title policy, we review the prior deed, we review all this information so that it's accurately reflected. The next important section as it relates to property is you also want to identify what personal property and fixtures will remain after closing. And you'll also want to properly document what personal property and fixtures will not remain. And oftentimes, especially if you're dealing in a multifamily property, you may not have that information until after your due diligence period. Another thing we oftentimes will put in a contract is we'll attach an initial inventory list. And this is even more important when your clients are buying a hotel property or an assisted living or other type of real estate where there's also an underlying business involved. So what we normally do in this particular section is we'll attach an initial inventory list, and then a day or two before closing, we'll have our clients do a physical inspection, or whoever the consultant is that does the physical inspection. They will ultimately, amend that particular exhibit of all the inventory prior to closing, and then we'll attach the inventory list to the bill of sale at closing. So again, this is often, and I can't stress enough, parties and property are often where the most litigation ensues, which you would think are pretty rudimentary sections of the contract. These are often ones where there's the most dispute. The next section that we want to talk about is due diligence or financing contingencies. So ultimately, you want these periods to run simultaneously because, and especially as a seller, you want these periods to run simultaneously. As a seller, you don't want multiple outs for your client, for the buyer to get out of this particular, to get out of the particular contract. And most importantly, if you don't ask for items in a due diligence list, you won't receive them. Always use a due diligence checklist, and each particular property has its own unique due diligence checklist. On the next slide, I'm going to give you a list of items that you should ask for in almost any commercial real estate transaction that you're looking for. Also, because most contracts have due diligence and the financing contingency run simultaneously, if you are the buyer or you are representing the buyer, you must have your buyer obtain the financing commitment from their lender, not a pre-approval or a pre-qualification, prior to the end of the due diligence period. Because once that period ends, the deposit, it's non-refundable, which we call, it's a hard deposit. And if you don't go to closing, your party can be subject to a variety of penalties, which we're going to talk about later in the default provision section. And make sure that your contract allows you and your consultants the right to inspect the property for physical inspections and testing during the due diligence period. Because we've had situations where, and you have to assume when you have a signed binding contract, there is no wiggle room, and each party will be held to their particular obligations under the contract. And so if it's not in the contract, I can't stress enough, if it's not in the contract, then ultimately you have to assume that it is not going to be something that you can gather, and it's not going to be something that you are going to be able to obtain. So most importantly, you want to, if you are representing the buyer, you want your buyer to have unfettered access to the property. You want your client and their consultants to have the ability to go onto the property without a long period of notice to access the property. Now, it becomes even more tenuous, though, if your client is ultimately running their business. For example, a hotel, and I'll give you a war story briefly. When I was a summer associate, I worked at a large law firm in my hometown of Syracuse, New York, and we were representing the seller of the largest hotel on the campus of Syracuse University. It was the Syracuse University Sheraton. So I had my whole file there, and when we went to lunch, silly me, I left my file in the room where we were meeting with management. The management went through, and then they informed all the employees that the property was going to be sold, and everybody was in a panic. Surprisingly enough, after that mishap, though, I did receive an offer to work for the firm after the summer. But needless to say, I learned a hard lesson that when you always have to be cautious of who you are discussing a transaction with, and you have to assume that they are not on your side. So always keep all of your notes confidential and know the parties, and assume that everybody is on a need to know basis, and do not disclose negotiations for a sale, especially because in New York, they require, if you're going to lay off a certain number of employees, you have to file what's called a warn notice with the state. And so everybody was up in arms and concerned that they were going to lose their job as a result of the sale of the hotel. I'm going to go next to the next slide, which is going to go through what items you should request during due diligence. And the list below is non-exhaustive. You always want to have the prior title policy and prior survey. This will help you understand what issues exist, at least at the time the seller purchased the property, and the prior survey. You want copies of permits and approvals. You want plans and certificates of occupancy for the property. You want to obtain a third-party zoning letter. You want to, generally speaking, especially if you're going with an institutional lender or an agency lender like a Fannie Mae or Freddie Mac lender, they require you to get a PZR report, which is a third-party institutional report. It's not just a simple zoning letter from the municipality. It goes into great depth, such as, is the property under code? Is it conforming? Is it non-conforming? How many legal property space? How many legal, parking spaces there are? So I strongly urge you to obtain that letter from a third-party source. You want to get prior environmental reports. You want to see if there's any governmental or administrative actions or orders as it relates to environmental issues. You want to get code enforcement violations, government actions. Now, these are prior items that you want to receive from the seller, but you always want to obtain an updated PZR report. You always want to obtain an updated phase one report and phase one environmental report. And if anything shows on the phase one environmental report, ultimately you're going to have to get a phase two report and soil tests and soil bearings. You want to get copies of prior current litigation. You also want to get copies if there's any threatened litigation, any demand letters, anything like that. You want to get copies of all the leases and operating and material contracts. You want to get copies of estoppel letters from tenants. You ideally and absolutely need these estoppel letters signed by the tenants, not signed by the owner or the landlord, but signed by the tenants. The title company requires this, and also you're going to need to know from the source, and you want to know that estoppel letter is going to contain what type of claims or other issues that may arise as a result of this lease. If there's any disputes as it relates to outstanding rent, if there's any prepaid rent, you need this so you can accurately reflect and provide on the closing statement, what types of deposits and credits and the like on that. You want to get a certified rent roll from the seller, and that rent roll should match the estoppel letter. So that's another reason why you need those signed by the tenants, because they all have to match up. You want engineering and other physical inspections. Most importantly, you want termite inspections, any mold inspections that were done, and you want to go back as far back as the current seller has. And if they have other information before that, you want to obtain that also. You want to know if there's any structural building systems and personal property warranties, and certainly are those assignable at closing. You want to know, what the vacancy rates are, what the current litigation, if there's any current litigation for outstanding rent or other issues with tenants or other vendors. And certainly, if there's any disputes, the estoppel letters need to match up. You want to get copies of the insurance policies for the properties, and also if there's any claim history on any of the insurance policies. And then if you have, and depending upon the asset class, you also want to get other property specific information, like for example, which is outside the scope of this webinar today, but if you're buying a hotel, there's a whole bunch of other business related reports that you need to receive. from the owner of the property so that you can really understand truly the operating history of the property. Title and survey. This is where myself as an attorney, we earn our keep. The title commitment will be from a national recognized title insurance underwriter. You don't want to accept an opinion of title from a lawyer. You want to have the backing of a title insurance underwriter. So at closing and you purchase a title insurance policy, if there is any potential claims, you want to have that policy to go back on. And those will include monetary encumbrances like mortgages or liens. It will include non-monetary encumbrances or restrictions, such as a use restriction on the property. It could be access issues. You want to, on the survey, you want your surveyor to plot any physical encroachments. Like, for example, if the driveway encroaches on an existing utility easement or a roadway or a sidewalk, you want to see other restrictions of record. Oftentimes there could be use restrictions. If you are buying a property in a shopping center with a shared driveway, there's going to be access use and business use restrictions. And that's also important when you're evaluating the property, because if you have a retail or shopping center, there may be prohibitions on certain uses or certain tenants that you have on the property. You also want to see any power lines, property setbacks, any code-related issues, conforming or non-conforming use. And then the title and survey, that the surveyor needs to outline the deed restrictions, the legal descriptions, and make sure that the legal description is accurate on both the title commitment and the survey, because the legal description in the title commitment and the title policy is going to be the insurable section of the property, and that's going to be the legal description that the title company is going to insure against in the event of any claims. Also, during the contract will provide the timing that you have to make those title and survey objections, what exceptions are permitted, and what the time frame is to cure any of those title defects. Conditions to closing. So these are certain milestones that must occur, and generally they're boilerplate. Many income-producing property contracts often have limited conditions to close unless an issue is discovered during due diligence. Like, for example, if you have a multifamily property and you discover there's some issues with the roof, you may want to delay closing until the roof is fixed. The tenant, and I gave you some examples. Also, for example, in a triple net lease, a tenant is responsible for taxes, insurance, repairs, and maintenance on the building. It is important to clearly outline the seller and the tenant's responsibilities and determinations. Now, really, if you have a property that's an income producing property that you're purchasing, really the only condition to close is really when the lender's ready to close, and you just have to time that right as it relates to the the closing date. Representations and warranties. So here's an example, and we've talked about a lot of these already. So a representation and warranty is just that the seller is representing that this is true and correct at the time of contract and the time of closing. This is often where litigation ensues if a representation and warranty is not correct. So very simply, the seller has the authority to enter in the contract and the proper person has signed the contract. The entity is in good standing. There's no litigation involving the property. There's no code or other governmental violations. There's no environmental issues. There's marketable title to the properties. And then certain special properties have their own particular representations and warranties. The buyer has very limited warranties generally. They're just an entity in good standing, and they have authority to enter into the contract. So deal makers and deal breakers. So default provisions, it's very important to understand what the default provisions are. And when I mention default, I'm talking about if a party doesn't perform under the contract. So generally, if a buyer defaults under the contract, the seller can retain the deposit and potentially can sue for damages, money damages, if the buyer doesn't perform. If we're dealing with a seller default, meaning the seller doesn't sell, the buyer can get a deposit refund. They can get a judicial, an order from the court for specific performance requiring the seller to sell. And they also potentially could sue for damages for seller default. And the important thing with default provisions is that you have a written notice and opportunity to cure these defaults before you go to court. And then also the other thing to consider is sometimes in a contract, they'll have a mandatory arbitration provision or a mandatory mediation provision, which may or may not prohibit a party from seeking redress from the court system. Also, most commercial real estate contracts will also include a waiver of jury trial. Very rarely do these real estate contract disputes go in front of a jury. Another solution is if there's any disputes related to the physical condition of the property or vacant rates or tenant evictions or repairs, oftentimes the contract will include an escrow holdback for a period of time to account for any unknown defects of the property. Okay, well, now it's time for our question and answer period, and I've seen a bunch of different questions, so I will go through these questions as we go along. Okay, and please ask any other questions that you have, because we have some time left over to answer these questions. First question is, and I've seen it a couple times, can I have a copy of this presentation once you are finished? The answer is yes, you can. I also will send you, once we upload it to our YouTube channel, I will send you a link to the presentation so you can review it at your leisure. And most importantly, I really thank you all for attending today. And I'd love for you to subscribe to our YouTube channel where we have this seminar and some of our previous seminars. And you'll be the first one to be notified when new content comes out. We generally provide at least 1 or 2 videos a week, and we usually have seminars every other week. So I look forward to seeing you in a couple weeks for our next seminar, but let me go through a couple other of the questions. One question was, how do you get the deed if the owner doesn't have it? And the way to get the deed generally is it's recorded in the public record, so it is part of the public domain. And as a result of that, you are able to, and most county recorders offices or county clerk's office have online access. But if your particular county where the property is located does not have online access, then you can go to the county recorder's office or your local courthouse and you can get a copy of that deed. And I highly recommend, as I mentioned before, to get that before you sign the contract. Okay, next question is, if a seller doesn't have any prior environmental inspection reports, then is it reasonable for the buyer to pay for such inspections at their expense and extend the due diligence period? And how about if the buyer considers the additional expense and asks for a credit if buyer decides to close? So yeah, that's absolutely understandable. So generally speaking, when I'm negotiating a contract, it usually takes at least 30 days. In a general climate during this time period, it generally takes even longer, but it usually takes about 30 days to get a phase 1 environmental report back. So you want to have your inspection period be at least 30 days, and then getting your engineers and building inspectors, that also could take 30 days. So generally though, most times, the expenses of due diligence fall on the buyer, not the seller. And so, it's rare that a seller will credit a buyer for the cost of inspections. Next question is, if you're working with the buyer and seller, and the seller says he or she has authority to sell, and we find out it went to probate, does the buyer's agent have the right to ask seller to produce a document showing his or her authority to sell? Absolutely. Ideally, before you sign the contract, you want that to happen. But ultimately, at the very least, because you may or may not have the right party signing the contract. If it's a probate, the personal representative has to sign the contract on behalf of the seller. Any other questions before we go? And certainly, I'm going to post right now in the chat my information. It's also on our slide, but my email address is wallace1@me.com. And if you want to learn more about us, our website is thewallacelawgroup.com. And we are on Facebook, we're on Instagram, and we are on YouTube. And I hope to see everybody soon. And I will send you all a link with the recording of this presentation when we post it to our channel, which should be probably early next week. And thank you all. Stay safe out there. And I look forward to seeing you all at our next presentation.